An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Sedition and prior restraint. The First Amendment was ratified in 1791. It provides, in part, Congress shall make no law abridging the freedom of speech. In this topic, we will study the original meaning of the freedom of speech. In 1798, the Federalist-controlled Congress enacted the Sedition Act. The law made it a crime to write, print, utter, or publish any false, scandalous, and malicious writing against the government of the United States with intent to defame the said government, or to bring them into contempt or disrepute, or to excite against them the hatred of the good people of the United States. The Adams administration used the Sedition Act to prosecute its most strident and vicious opponents in the Republican Party. At the time, Federalist-appointed judges dominated the federal judiciary. Republican-controlled legislatures in Virginia and Kentucky issued resolutions declaring that the Sedition Act was unconstitutional. James Madison is credited with authoring the Virginia Resolution, and Thomas Jefferson is credited with writing the Kentucky Resolution. The Virginia Resolution declared that the Sedition Act is unconstitutional, but it did not claim the power to unilaterally nullify the Sedition Act. Instead, the Commonwealth enlisted the opinion of other like-minded states. Virginia also stated that the Commonwealth has, quote, the right and are in duty bound to interpose for arresting the progress of the evil. Through, quote, interposition, the state government intervened to assert the rights of its people against the assertion of power by the federal government. Interpose was different from nullification, though one could favor both interposition and nullification. The Kentucky Resolution, thought to be authored by President Jefferson, did use the term nullification. However, it is not clear that the proponents of the Kentucky Resolution believed that a federal law would become non-operational because once they believed it to be unconstitutional. Instead, the resolution authorized a formal protest against the Sedition Act's unconstitutionality. It provides, in part, quote, that although this Commonwealth, as a party to the federal compact, will bow to the laws of the Union, yet it does at the same time declare that it will not now, nor ever hereafter, cease to oppose in a constitutional manner every attempt from what quarter soever offered to violate that compact. In 1800, James Madison wrote a lengthy report that defended the Virginia Resolution from its critics. In his report, Madison explained that there's a difference between when a state declares a law unconstitutional and when a court declares a law unconstitutional. Quote, the declarations by states are expressions of opinion, unaccompanied with any other effect than what they may produce on opinion by exciting reflection. The expositions of the judiciary, on the other hand, are carried into immediate effect by force. The Virginia and Kentucky resolutions illustrate how the Constitution is interpreted outside of the courts. In the election of 1800, Jefferson narrowly defeated Adams, in part due to the controversy surrounding the Sedition Act. This election came to be known as the Revolution of 1800. As president, Jefferson pardoned those who had been convicted and imprisoned under the Sedition Act. In Madison's report of 1800, he argued that the Sedition Act violated the First Amendment. His discussion illuminates two theories about the original scope of the right of freedom of speech. Under the first theory, the government cannot impose what is called prior restraints on the freedom of speech. In other words, people cannot be silenced in advance of speaking. But on this reading of the freedom of speech, people can still be punished for their speech after they speak, according to the common law. In England, the right of freedom of speech could not be limited through prior restraints. We call this first theory the British theory of freedom of speech. The second theory is distinctively American, and it was defended at length by James Madison in his report of 1800. Madison contended that the British conception of the freedom of speech was aimed only at prior restraints by the Crown. It did not limit the powers of Parliament, because the British Parliament was considered supreme. This principle is called parliamentary supremacy. Madison contended that the U.S. Constitution rejected parliamentary supremacy. Under the American theory of popular sovereignty, Congress is also subject to the law of the Constitution, including the First Amendment. Therefore, federal legislation that punishes speech after the fact is also unconstitutional. Indeed, the First Amendment begins, "Congress shall make no law." Under the American right of freedom of speech, then, it is unconstitutional for the government to constrain the exercise of free expression both before and after the fact. At the time, the Supreme Court did not rule on the constitutionality of the Sedition Act. But today, the courts have accepted Madison's interpretation as the original meaning of freedom of speech. For example, in New York Times Company v. Sullivan, 1964, the Supreme Court favorably cited Madison and Jefferson's criticism of the Sedition Act. Justice Brennan wrote for unanimous court, quote, "Although the Sedition Act was never tested in this court, the attack upon its validity has carried the day in the court of history."